Okay, Assalamualaikum, Doctor. We are from L1 and we will be presenting about the case study between Catherine and Melina. So our group is Afika Usna, Khairul Sabri, Nur Izzati, Nur Sofi Iliana, and Tan Kim Soon. Okay, the case study content is issue, law, which is the statutory, court cases, and application. Okay, for the issue in this case is whether Catherine is applicable to sue Melina in court for breach of contract or not. Okay, I will pass to the next presenter. Thank you.
Hi doctor, my name is Tan Kim Soon and my matric number is 81880909. I will present about the element of contract law. Okay, for the element of contract law, there is 6 elements. Okay, the first one is offer. Okay, to form a contract, it must start from the offer. At least 2 party or more than that party are needed to make a offer and legal in order to form a contract. When make an offer, these 2 parties must know what is being offered and the return of the offer of the that have been made. They also should know the details of the offer, include the term and condition. Okay, the second is acceptance. Acceptance is second element in order to respond the offer that has been made. When the offer is going to next level, the other party has choice to choose either to accept or rejecting the offer. Contract still cannot be made when these 2 parties are still discuss and did not reach an agreement about the offer. Okay, the third element is consideration. Consideration is one of the important element in contract law. It is because consideration in contract law is referred to the other party giving back something as exchange, either product, money or service. Both parties that involved must get something from the contract and need to make exchange that have value. Okay, for the next element is intention to create legal relationship. Okay, for this element, it is referring as intention to form a legal binding contract. To form a contract, the element of the intention to create legal relationship is must. Okay. A contract cannot be formed just because of the agreement of the 2 parties, but it still must have legal binding agreement. This is because when already agree with the contract, it must follow and accept the legal sequence if happen anything. Okay, for the next element is certainty. Okay, both parties must clear and understand the term and the agreement of the contract. If both parties do know the term and agreement, the contract is no longer can count as valid. Okay, for the last element is capacity. Capacity is referring to the people or party that involved in contract that have must capacity to do it in order to become a valid contract. Both parties must be people that can think properly when dealing to form a contract. So that's all for me, and I will pass to next presenter.
Communication. In section 9 of contract at 1950, state 2 types of communication, namely communication implied, non-verbal, and express verbal communication. Second, we go to the target group. The offer must be made to specific person and cannot be made public in general. According to section 2A of the contract at 1950, a person is willing or unwilling to do something in the hope that the other party accepts. The last one is the intention of make an offer creation means the promiser must demonstrate the intention to make the offer by making it possible for the other party to comply. Thank you.
Okay, next is court cases. In this section, I will explain about 2 court cases. First one is Maritime National LDT versus Ocean Trawlers LTD 1983, where the defendant fishing vessel does not have a license according to the law, then the claim fails to get the license for a defendant, but only a 3 claim license are granted and excluded the claimant 1. The contract was not frustrated since the claimant had chosen to keep the 3 licenses granted for himself rather than using one to fulfill his contractual obligation. He had therefore induced the frustration event and was therefore in the breach of contract. Next court cases is Davis Contractors versus Frahim UDC 1956, in which the claimant agreed to build 78 houses for the Frahim Council within 8 months for a certain price. Due to a shortage in the skilled labor and material, the contract took 22 months to complete and was much more expensive than anticipated. David contract will pay the contractual agreed price, but bought the action argued for the money based on the facts that contract has become frustrated, and therefore they were entitled for a further payment based on a quantum metric basis. The contract was not frustrated. The facts of the contract become more difficult to perform or not profitable. It's not sufficient to amount of frustration. It was still possible to perform the contract, so it is not a contract breach contract. Thank you.
Okay, better. For the application part, in the cases of Melina and Catherine, we highlight for some Contract Acts 1950 and the section of that. Okay, for your information, firstly, we use about the Contract Acts 1955. This is because due to the existence of a relationship between 2 or more parties. Okay, next is about the section 2 bracket A of Contract Acts 1950, which is the situation where anyone can do or do not do something in the hope that the other party accept it. In addition, understanding the words of the statute, it can be safely stated that it is very important that the offer means making an offer to another party. Okay, next is about the section 3 of Contract Acts 1950 that is applied in this problematic situation. Through the use of this section, it is clearly stated that communication is important to make any offer to other parties. In the meantime, this situation can also be done with action permission. However, silent action will not be the same as communication because it can be seen if a person does not respond or remain silent. Okay, next is the section 9 of Contract Acts 1950. To this section, it states that the type of communication is implicit communication, non-verbal communication, and expression verbal. This situation state the implicit, non-verbal, and others, and the symbol and sound only. Express oral communication is the use of verbs. Okay, I will pass to the next presenter.
Okay, in conclusion, we can see that Catherine does not fulfill the requirement for breach of contract and is not applicable to sue MELINA. We can see by making a legal contract, it must have some elements that are met to pair. If the contract does not meet any of the contract elements, then it is well considered that the contract is invalid and it does not comply with the contract, which in another word, we can say that the contract can be considered. Okay, that's all from us. Thank you.